The Supreme Court just handed down a shocking 920 ruling that adjustments how police can enter your home without a warrant. All 9 justices agreed, which almost by no means happens. And that on my own tells you this is not a minor issue. This choice doesn't just affect one kingdom or one case. It resets the boundaries national. From late-night welfare assessments to quiet knock and input searches, the guidelines simply modified. If you care approximately your privateness, your firearms, or your rights under the Constitution, this is something you want to pay attention. So, let's get into what absolutely passed off and what it now approach for you. Disclaimer, I'm no longer a legal professional, and this isn't always legal advice. Gun legal guidelines are converting speedy, and they're distinct anywhere. Always test with a legal professional and your local legal guidelines before making any selections. The 920 ruling that greatly surprised the state's criminal gadget at precisely 10 hours Eastern. The Supreme Court dropped a decision that sent a jolt via the criminal world. Not a 5-4 cut-up, not even a 7-2. This turned into a smooth 9-0 ruling. Every unmarried justice from Clarence Thomas to Ketanji Brown Jackson signed off on one unified opinion. And what they just agreed on ought to rewrite the regulations for police entry into your home in approaches we haven't visible in a long time. To recognize how rare that is, consider this. The Supreme Court handiest reaches unanimous agreement in approximately 3 out of 10 instances. And on the subject of instances related to Fourth Amendment rights, searches, seizures, warrant exceptions, full agreement is sort of exceptional, much less than 15%. So whilst all 9 justices lock fingers on in trouble this personal, this arguable, it is extra than only ordinary ruling. It's a criminal earthquake, and the timing could not be extra crucial. Right now across the U.S., there are over 340 ongoing instances in each federal and nation courts that hinge on this very problem. Whether regulation enforcement can enter your own home without a warrant at some stage, and so referred to as emergencies or welfare assessments, judges, prosecutors, and protection lawyers have all been waiting on this ruling because it doesn't simply offer guidance. It draws a state-of-the-art constitutional line inside the sand. Justice Ketanji Brown Jackson authored the opinion. And to what's particularly noteworthy is that she failed to just write a compromise. She wrote a selection that managed to bridge the ideological divide on the court docket. That's extraordinarily rare. She created wording that satisfied both originalists and progressives. That tells you ways serious and considered this opinion became. But here's what most people nevertheless don't apprehend about this case. The court failed to simply cope with one music felony trouble. They tackled 3 most important constitutional disputes that decrees courts have been suffering with for years. One of those, an arguable policy called the network caretaking doctrine. A policy it truly is been quietly used by police to justify walking into houses. No warrant, no crime scene, just difficulty. And that quiet policy, the one hiding in felony shadows for over a decade, the Supreme Court simply lit it up. The hidden loophole that allow police enter houses without a warrant. For years, regulation enforcement throughout the UAS has been using a backdoor maximum Americans by no means even knew existed. It's called the community caretaking doctrine, and it allowed officials to walk into your property, no longer due to a crime. Now, not with a warrant. However, definitely due to the fact they claim to be involved. Now, here's the trap. This doctrine become in no way designed for houses. It firstly came from a case regarding damaged down vehicles on highways. The concept became that police ought to help with roadside safety without needing a warrant. But through the years, not to let good judgment were given, twisted, stretched from public roads into personal living rooms. Between 2015 and 2023, the variety of domestic entries justified below this doctrine exploded, up 340% in line with the National Association of Criminal Defense Lawyers. That's now not a misprint. Hundreds of Americans each observed officers enter their music homes, not due to proof or warrants, but because a person felt something might be incorrect. Let me display you ways clean. It was for this loophole to get used. Imagine your neighbor hasn't seen you in a couple of days and calls the police out of concern. You're now not home. Maybe you're on excursion. Maybe you're simply worn out and ignoring the door. Officers knock, wait a few minutes, then decide to head in. No crime, no warrant, simply concern. And this wasn't hypothetical. In Montana by myself, 47 instances like that passed off closing year. In one, officers entered a person's domestic after a member of the family stated he seemed depressed. Inside, they discovered legally owned firearms, making music, and used crimson flag laws to confiscate them. This is the form of overreach the Supreme Court just took a hammer to. But what they did wasn't only a mild adjustment. They did not place new limits on the network caretaking doctrine. They obliterated it. They stated it has no place, none, as a felony justification for coming into homes. And that ruling does not simply alternate things going forward. It throws a prison grenade into every case that relied on this doctrine inside the beyond decade. What truly music occurred in this situation will go away, you speechless. The case on the center of this Supreme Court bombshell comes out of Montana, and once you pay attention what genuinely took place, you'll recognize why the justices stepped in. It started out overdue one nighttime, simply beyond 11 p.m., when a woman known as the police, approximately her ex-boyfriend, a man named Trevor Casses. She failed to record against the law. She didn't claim violence. She surely stated she had an atypical feeling after a smartphone name. Maybe he sounded disappointed. Maybe she heard a gun cock. Maybe he stated something about harming himself for the police. She wasn't positive. She admitted she couldn't do, not forget Shirley. Still, 4 officers were dispatched to Cassis's domestic. Now, here is a vital detail, and all 4 of them, for my part, knew him. They didn't smash down the door. They waited for 40 minutes. They knocked, flashed lights through the home windows, and called his call. No solution. Peering inner, they saw a gun holster sitting on a table, empty. Next to it, a notepad. That turned into enough. Without a warrant, without a crime scene, and without any actual emergency, they opened the unlock to the front door and walked in. They determined Cass hiding in a bedroom closet. One officer claimed he saw a black object in Trevor's hand. Could have been a telephone, a wallet, or not anything in any respect, and fired his weapon. Cass has survived the shot. However, what passed off next might be even extra traumatic. After the capturing, police searched the room and discovered a firearm in a laundry basket, and that became the idea for criminal charges. Think approximately that no warrant, no crime in progress, no urgent hazard showed, an indistinct telephone call, and an empty holster have been all it took to justify a full home entry, a shooting, and prison costs. So, right here's the hard query. If a person called the police on you right now and said they had been involved, should officers have the power to enter your home, poke via your property, and arrest you for what they find? That's what this case forced the Supreme Court to confront, and what they determined should change how every home entry is judged from this point ahead. The 3 felony regulations that put your rights on a map before this ruling dropped. America wasn't working below one rule ebook whilst it got here to emergency police entries into your property. In truth, it changed into chaos. Courts and exclusive states were the use of absolutely one-of-a-kind prison standards, which meant your constitutional rights failed to come from the Bill of Rights. They came out of your zip code. In one state, what officials did is probably prison past the border, and it could get thrown out in courtroom. That form of legal whiplash has been irritating judges, perplexing officials, and alarming civil rights advocates for years. Let's smash down the 3 requirements that had been battling it out in courtrooms across the U.S. The first turned into, in all likelihood, purpose, the gold standard. This is the equal stage of proof required for a seek warrant. Roughly 12 states held to this rule, and it offered the maximum protection. But in fast-moving situations, looking forward to likely cause will be too gradual. The risk a person may want to get harm even as police gather sufficient proof. The second became reasonable suspicion, a miles decrease bar. Officers simplest wanted unique facts that might lead an inexpensive character to suppose something become wrong. Around 23 states observed this check. It gave law enforcement more room to behave speedy, but also opened the door to assumptions and intestine emotions, gambling a larger function than data. Then there was the 13 and the most debatable, the network caretaking doctrine. About 15 states have been still allowing this. It changed into the loosest widespread of all. Officers may want to input a home without a warrant, without in all likelihood motive, and every so often without clear evidence, so long as they stated it turned into for safety, not for law enforcement. That's how we got here. The Supreme Court simply rewrote the rule ebook. Now, here's the twist no one predicted. The Supreme Court failed to pick out any of these 3 requirements. They tossed the playbook and wrote a new one. The court docket created what is now known as the Objectively Affordable Foundation Test, and that is the new National General. Under this, take a look at police can input your home without a warrant only if they have clear and goal motives to consider that someone inside is both seriously injured or facing in music, coming near risk of serious damage. Not maybe, not possibly. Now, not based on a horrific feeling or vague concern. And it's not approximately what a particular officer believed within the second. The court docket made it clear it's what any affordable officer in the same situation could have believed based at the data available at the time. Here's wherein matters get real. The court even laid out key questions officers need to now bear in mind. Was there a reputable and precise document of chance? Who gave that report and what exactly did they are saying? Did officials study whatever at the scene that showed or contradicted the danger? Legal analysts say this new rule lands among the antique. It's more difficult than affordable suspicion, however, not as strict as probable motive. It offers officers a route to behave in real emergencies. But it also draws a hard line towards guesswork and assumptions. But there's one big problem nonetheless hanging within the air. The courtroom failed to outline how serious the harm must be, or exactly how approaching is impending. And that gray location, it's going to spark lots of prison battles over the next few years. One issues for positive that the times of indistinct entries and blanket justifications are over. Officers will now need information, not feelings. Why the Supreme Court still ruled against Trevor even after changing the regulation. Now here's the part, it really is sparking heated debate in regulation schools across the U.S. of a yes, the Supreme Court struck down Montana's prison reasoning. Yes, they rejected the outdated preferred that let officers barge into homes beneath vague pretenses. But even after raising the bar and rewriting the law, they still ruled towards Trevor Cass. That's right. The justices said in simple terms, Montana used the incorrect take a look at, but after they implemented the new take a look at, the objectively affordable foundation widespread, they nevertheless concluded the police entry turned into lawful on this precise scenario, and that choice is elevating a number of eyebrows, as it weigh that even under stricter music regulations, some domestic entries like this will still skip constitutional overview. So what tipped the scale? The court listed 5 key statistics that taken together justified the access. A report from Cassis's ex-female friend suggesting he is probably suicidal and likely violent toward police. The officer's private understanding of Cassis's beyond mental health struggles. The empty gun holster noticed through the window, hinting a firearm become unaccounted for. 40 instantly minutes of knocking, shouting, and flashing lighting fixtures met with zero reaction. The timing. It became overdue at nighttime, and there were more than one caution signs and symptoms adding up. The court docket said that any reasonable officer searching at all of that might trust a person, internal might be hurt, or making plans to damage others, and that changed into enough to fulfill the brand new constitutional music popular. Still, felony specialists are pushing back. They argue that Cass become under no obligation to answer his door. Being silent in your private home doesn't mean you have surrendered your rights. Some see this ruling as giving too much advantage of the doubt to police, even if the records are fuzzy. And if you're thinking whether this decision split the court, it did not. There turned into no dissent. Every justice agreed. But that does not mean there have been no issues. Several justices wrote concurring evaluations, meaning they agreed with the outcome, but flagged capability troubles for destiny instances. They're concerned approximately how this new widespread might be stretched or misused. So, right here's the query all of us need to ask. If you are sitting at domestic overdue at nighttime and pick out not to open the door, should police be allowed to or available? Besides, just due to the fact someone stated they have been concerned, this is the tension at the heart of this ruling, and it is from settled. Hundreds of cases just got thrown into prison chaos. Now that the dirt has settled on the Supreme Court's ruling, the fallout has already begun. Remember those 340-plus instances sitting in courtrooms across the United States of America, all concerning police getting into houses without warrants under indistinct emergency claims. Those instances just got flipped the other way up. Defense legal professionals are not waiting. They're already making ready motions to reopen instances, arguing that the antique prison requirements at the moment are invalid. On the alternative facet, nation prosecutors are scrambling, reviewing convictions, looking for backup proof, and looking to discern out which cases can continue to exist under the brand new rule and which might be about to crumble. And right here is the timeline. Within the subsequent 90 days, courts throughout the country will be forced to reanalyze every one of those instances. Not beneath the antique community caretaking excuse, however, beneath the brand new objectively affordable foundation test. If a case hinged on vague issues, it's probable getting tossed. But if police had stable, specific statistics pointing to severe damage, some of the one's convictions might nevertheless stand. The Ninth Circuit by myself, which covers states like California, Arizona, Oregon, Washington, and Montana, is handling 73 of those instances. And it truly is just the federal degree. State courts are approximately to get hit even tougher. According to the National Center for State Courts, nearly 2,800 active nation appeals involve warrantless home entries. That's lots of cases that judges' idea had been achieved now suddenly again on the desk. Defense legal professionals can be filing for reconsideration. Prosecutors must shield their vintage cases below a contemporary rule ebook. And judges, they may be stuck reinterpreting rulings they notion were settled years ago. But there is one class of cases causing the most difficulty, and it's the only maximum humans have not even thought approximately yet: the pink flag laws. Because how this new preferred applies to firearm seizures and mental health calls is going to cause a whole new round of legal battles. And that fight is just starting. Well, what this indicates for you, beginning now. So what does all of this in reality mean for you right now within the actual world? It's not simply criminal theory anymore. This choice adjustments how police are allowed to approach the front door, input your home, and use what they discover. First, permits start with something easy but effective. If officers knock, and also you don't answer, that on my own is no longer enough. Silence is not suspicion. Just because you do not come to the door does no longer mean they could allow themselves in. The court made it clean. Without sturdy goal reasons, music to trust a person is severely harm or an instant risk. They cannot move that threshold. Second, if someone calls in a welfare test on you, police now need information. No longer emotions. An indistinct file, which you appeared off or were not returning texts, isn't sufficient. They must have real articulable proof that damage is happening or about to appear. Third, and this is critical for gun owners, the presence of firearms, even if they're visible through a window, does now not deliver police automatic entry rights. Gun ownership isn't a red flag with the aid of itself. Millions of Americans' personal firearms legally. That by myself does now not create an emergency. But right here is the caution. If a couple of factors stack up, shall we say a family member claims you're suicidal. Police recognize your mental fitness records. They see a weapon through the window, and you're now not responding. That aggregate would possibly nonetheless justify entry beneath this new standard. Fourth, don't forget this ruling best applies to emergency entries without a warrant. If police have probable reason that you committed against the law, they can still get a warrant or act underneath different exceptions. So, what's the lowest line? The court docket simply positioned real limits back in area. They restored limitations that had been getting blurry, but those limits depend upon facts. And in real life, records get messy. That's why understanding your rights isn't always optionally available anymore. It's vital because whether or not you're domestic alone on a quiet night, or someone makes a decision to make a name in your behalf, this new criminal trendy can be the one aspect standing between you and a life-altering state of affairs. What this indicates in your rights starting nowadays. Let's get actual starting now. This ruling has direct effect on how your rights work inside your house. First, if police knock and also you pick now not to reply, that doesn't imply they can walk in. Staying silent isn't always a crime, and it is now not an inexperienced light for compelled access. The Supreme Court has now showed this protection applies in every country. Second, if someone calls in a welfare check approximately you, police cannot simply come internal due to the fact a person stated they were concerned. They want clean goal motives to consider someone inside is significantly hurt or an immediate threat. A vague problem is no longer sufficient. Third, and this matters for gun owners, having firearms in your private home, even if they may be visible through a window, isn't always enough to justify a warrantless music entry. Millions of Americans legally own guns. The court made it clear that firearm possession by way of itself doesn't create an emergency. But if numerous hazard factors are present at the identical time, it is a one-of-a-kind story. If a person reports which you might be suicidal, officials see a weapon, you're now not responding, and they have earlier data that increases issue. The one's combined records could meet the new well-known. It's now not about one thing. It's approximately the whole photograph, and whether or not an inexpensive officer could trust a severe threat exists. Fourth, this ruling doesn't exchange the policies and crook investigations. If police have likely reasoned that a crime was dedicated, they can nonetheless get a warrant or act underneath other exceptions already allowed by law. In simple phrases, the court simply put limits again in which they belong. It raised the bar for while police can enter your home without permission. But like maximum prison selections, the info, remember, that's why knowledge your rights is not non-obligatory anymore. It's your safety, whilst no one else is there to speak for you. Final mind. So here's the large query. Did the court docket finally shield your privateness, or did it simply create greater gray areas for destiny abuse? One issue is obvious. From these days ahead, silence at your door is not a criminal offense. Vague worries are not sufficient, and your rights enter your home simply got a serious improve. That's the entire breakdown of this landmark selection brought to you by means of Law's Caliber updates. If you located this useful, hit like, drop your thoughts underneath, and subscribe so that you in no way omit a moment whilst your freedoms are on the